And of course, we saw dramatic, events in that courtroom in Pretoria. At the same time, the day two of the Section 194 inquiry into suspended public protector Advocate Mkhwebane's fitness to hold office was not without its own drama. We saw some heated exchanges between Advocate Dalimpofu as well as the witness that had been called, the first witness of that particular inquiry, Hassen Ebrahim, also got his credibility as a constitutional expert questioned. But let's look at these two matters now with Advocate Modidima Mannya, who's a legal expert who joins us now. Advocate Mannya, let's start first with this dramatic turn of events that we saw this afternoon. Did you foresee the withdrawal of Advocate Malesela Teffo?
Well, I must say I thought it was a long time coming. And it was bound to happen at one point or the other. But I didn't think that he was going to finish the trial.
And what do you make, though, of the continuous exchanges between him and Judge Maumela? I mean, we even saw it this morning where even Judge Maumela was saying, you can't tell me how to run these proceedings. I came here expecting heads of arguments. I did not get the heads of arguments. But he then arguing, saying that you also can't interrupt me.
You know, Bongiwe, even just in normal human interaction, there's some basic decorum that you follow when you discuss with people. And you can imagine what often happens if two people are speaking at the same time. It never ends well. But in the court setup, the presiding officer, whether it be a magistrate or the judge or a person chairing a hearing or whatever, is the person in control of the proceedings. You cannot go there and dictate how the procedure should be because there are rules and that person has the authority to ensure that the rules are complied with. I think the biggest challenge in this matter has been that the defense for accused 1 to 4 has not actually been following the procedures that are prescribed. If you have an issue that requires a substantive application, you file a substantive application. The same applies if you were to withdraw. In a matter of this nature, you have to make a detailed application to court to indicate why you are withdrawing. But I must say, and I've said this before, that there's often instances of robustness between counsel and a presiding officer, and there's nothing unusual about it, but as legal practitioners and as officers of the court, we have a duty to assist the court to function. You will recall that it is not only Judge Maumela who has had these challenges. His own colleagues, Advocate Mshololo and Advocate Maloi, at some point were called not left and right, not learned as well. So I just think that there is a problem. But I must say, I don't think this represents all of us in this profession, and I don't think it should be a standard, and I think people shouldn't look at us as people who behave in that manner.
Listening to him, he says that he remains on a watching brief for the Meyiwa family. Does this essentially mean technically he's still involved? Talk to us about what this means then and the role he's going to play going forward.
You know, to be frank with you, I've never understood it because I thought that at the beginning he was on a watching brief for the Meyiwa family, but we know that Advocate Kerinel is actually on a watching brief on behalf of the family. I'm not sure who exactly is instructing him in the family. But that aside, I would find it very confusing because the family are sort of the aggrieved complainants in this matter. And I would find it difficult to represent people who are before court accused of having offended those people and at the same time saying, I'm keeping a watching brief. So this is quite an unprecedented and unusual situation, I must say.
And this, of course, is likely to result in some serious delays because you look at the fact that whoever's coming on board now has to familiarize themselves with this matter. But at the same time, there's also going to be the issue of getting access to those transcripts. This could be, really a matter that we see delay again, on top of what we've seen so far.
Yes, but Bongi, bear in mind that this current legal team is the second legal team for the accused. So they had indeed had to familiarize themselves with the issues. But I think that the bulk of the record will basically show that the the bulk of it does not really deal with a lot of substantive issues with regard to the evidence. I know that Advocate Teffo has cross-examined and Advocate Msololo was in the process of cross-examining. But you will recall that in between, there's been significant delays and interruptions, including Advocate Msololo's cross-examination not being completed. But be that as it may, any legal practitioner will take of the matter, will have to familiarize themselves. They will be able to evaluate how much time they require, and they will be able to make a presentation to the court on how much time would be required for them to be fully on board on the matter.
Before we shift gears and go to that Parliament inquiry, I'd like to very briefly then ask you, how much of a disadvantage is this then going to be for the Meyiwa family, who are still waiting for some kind of answers, to the murder of their son?
Well, look, I mean, any delay, whether it's an hour or a day, is an inconvenience for people who are really wishing to see justice. They need closure. But at the same time, I think the type of process that must be followed must be, proper. It must not result in a situation where it will prolong their grief. The accused have fair trial rights, so they are entitled as a matter of law to have legal representation. So in a way, they have to be the striking of a balance between the two interests. But I think that the matter will ultimately get off the ground and proceed to its logical conclusion.
Turning our attention to Parliament now, it was a tense afternoon. I mean, I was listening to Advocate Dalimpofu, for example, getting into an exchange with the chair, at the same time an exchange with the witness. He sought to really cast doubt on the credibility of the witness, suggesting that he may not be the right kind of expert witness for these proceedings. Would you say he succeeded?
Well, look, I wouldn't be able to express such an opinion, but maybe just to indicate that, the witness who was there today, more than anything, I understood him to be there to give a proper context and to sort of assist, especially those members of the committee who may not be familiar with these legalities and roles and responsibilities. For me, the real evidence will start when a question is asked or evidence is given about whether you met the state security agency, whether you met the president, whether you disclosed that. That is really the crux of the evidence. This witness may be called an expert, but I think it's a bit of a tall order with that type of evidence to call that person an expert. But I mean, his evidence is not irrelevant for the purposes of assisting the committee to do its work.
And listening to him in his lengthy, submission when he was taking the inquiry through that report, one of the issues he says that could come into play at a later stage is that the public protector can only investigate matters within 2 years after they've occurred. And he says that this is a limitation that is set up by the Public Protector Act. And she says that, of course, according to what the courts have said previously, that there should be special circumstances that justify her in doing this. What does this then mean, according to your understanding, when one thinks, for example, in relation to the South African Reserve Bank report and that SARS rogue unit investigation, because these also form part of the case against her?
Bonga, I hope I'll be able to simplify this. Our system, our constitution, envisages what we call the principle of legality. The principle of legality, in simple terms, means that you can only perform those powers or exercise those powers which you are vested within law. So if the law says you can only do something up to here, you are limited in law to do it up to. Once you go over the period that is prescribed by law, then you are crossing the boundaries and your conduct will be unlawful. Now, of course, the question is, if you did that, what was the reason why you did it? Were you not aware that you are not supposed to do it? Or was it deliberate that you did it? Or you had maybe an ulterior motive? And I think those are the questions that the evidence will have to answer.
And when you look at, the case in it itself, from the view of her lawyers, they keep on hinting at the alleged illegality of this particular process. It's still a huge issue for them, even as you listen to them on day 2. How much weight will this argument have, considering where we find ourselves with the proceedings right now?
I can tell you, I think that issue can be raised as many times as people wish to, but I don't think there's any basis whatsoever to even suggest, never mind, make a firm allegation that this process is illegal. This process is based on the rules. These rules were passed lawfully by the National Assembly. These rules were tested by the court. You'll remember that two of the rules with regard to legal representation and the participation of a judge were struck out by the Western Cape High Court. And in fact, when the matter went to the Constitutional Court, the court only struck out one aspect, which is her entitlement, the entitlement of the Chapter 9 head to legal representation at state expense. I do not know what would constitute an unlawful act when Parliament is performing its functions. Maybe it's important to, because, yesterday we spoke about this uncharted waters business. By the way, this whole process is about, as the Constitutional Court characterized it, holding the head of the Public Protector Office accountable. And they said, the court said, it's a constitutional mandate, it's a constitutional requirement. Who else is better placed to do it in terms of our constitution? The power is assigned to the Parliament of the Republic of South Africa. The Parliament has made up the rules. Those rules have been tested. So I'm really not certain about what is the basis of the illegality of this process.
All right, Advocate Mannya, thank you so much for your time. Do appreciate it. That was legal expert Advocate Modidima Mannya.